Well, good afternoon. I'm Sue Hutchins, and this is Iowa Prison Perspectives. I realize that I haven't been on for quite a while due to some health issues and also some other organizational things and some legislation that's been going on in Iowa. But I am back today with a pretty unique situation and person for you to listen to. Iowa Prison Perspectives is has been designed to let you, the public, hear from people who currently are incarcerated, who have been incarcerated, loved ones of people who have someone that they love who's incarcerated, advocates like myself who work and try to make some changes in the criminal justice system, specifically here in Iowa, but also in some of the surrounding states, because we have found that legislators oftentimes are interested in what's happening in our border states. So we are connected with not only Iowa Prison Perspectives does not stand alone, we are also connected with Restoring Iowa Citizens, Iowa Justice Action Network, and Iowa Cure, as well as Living Beyond the Bars of Iowa. We have reentry interests, and Living Beyond the Bars has a reentry program, and the other organizations are about education, information, and legislation. I'm very interested in what you have to say, how you feel, what you think about what you're going to hear, what you think about any of the interviews that you listen to. So please feel free to contact me at Iowa Prison Perspectives at gmail.com. And that's IA Prison Perspectives at gmail.com. And once again, I'm Sue Hutchins, and welcome. The person that's going to be talking to you today is currently incarcerated in in the city, in not in St. Louis, in Missouri. I believe he is from St. Louis, but I could be wrong about that. He has a very unique story to tell because he is in the process of getting out, based on some DNA evidence that he and his team have found over a course of years. And he's here to tell you whatever it is he thinks would be important for you to know about his story. So I'm going to turn it over to him, and he's on the phone, and his name is Fredrick. So, Fredrick, if you want to start talking and tell us what you want us to know. Are you there? Okay. So go ahead and tell us what it is you want us to know. Can you hear me? Okay. Um, So you can go ahead and talk and tell us what you want us to know.
My name is Fredrick Lowebey, and I am from out of the city of St. Louis, where I was convicted in the 22nd Judicial Circuit in the city of St. Louis, Missouri. I'm locked up for the false rape, sodomy, and the tampering with the witness of my victim in the city of St. Louis, which came at the hands of two police officers who I've had previous occasions be falsely charged with drug charges by these officers, ruminating in James Law. As a direct result of me being found not guilty of those drugs these officers put on me in April of 1988, I was threatened by both of these officers telling me that I wasn't going to walk sweet until 1988. As a direct result of that, in May 1988, victim claims that she had got into an argument with her boyfriend, and she got out of the car with her boyfriend and walked home. And she said that three unknown individuals were supposed to have been asking her if she wanted to ride home at 5 something in the morning. And as a direct result of that, she told the guys that she did not want a ride home. And the guys drove their car in the opposite direction, made a U-turn, and came back toward her. One of the guys, she claimed, jumped out of the car and grabbed her by the hair and drove her into the house. And the other two guys had drove the car up in the alley, and accompanied the other guy that was supposed to have drug her in the house. And this other guy that she claims that raped and sodomized her was supposed to have been me because she was suspect number one. And the whole situation that they said three guys committed this offense. I'm the only individual that ever been arrested for this case. While I was locked up, the victim claimed that I called and threatened to have her killed if she did not drop the charge. It wasn't me. It wasn't me who called her. I don't know who it was that called her, but the telephone company says that they had 13 previous phone calls, placement equipment on her phone, and it was 13 previous phone calls that was received from individuals that they never identified. But neither of the 13 phone calls came from me. As a direct result of that, the jury found me guilty based off of what the victim came in the courtroom and identified me as being innocent. In 1988, we did not have DNA in the city of St. Louis. So during the time of my trial, I was supposed to go to trial with illegible documents, illegible medical documents that the St. Louis Circuit Attorney's Office, who also prosecuted me on the drug charges, had given us. So we could not discover any evidence that was contained in the medical reports that they had. And we tried hard to get those documents, but the Circuit Attorney's Office said that all the documents had looked just alike. Push come to a shove, it's time to go to trial. We are in trial. And while we're in trial, the victim claims that the individual that raped her, which is she's saying is me, the person that raped her, was the one that sodomized her and the one that she heard threaten her on the telephone on June the 1st, 1988, after the rape was supposed to have been committed. And the jury found me guilty based off of the fact that the victim was able to identify me as being the suspect, and I was the only suspect ever charged in this case. Moving up to the DNA situation, we're now situated because my appeals were denied in the regular trial proceeding. So Missouri instituted a DNA statute for guys like myself who've been charged with crimes and DNA can exonerate you. As a direct result, I petitioned the court for DNA testing. The St. Louis Circuit Attorney's Office contested my petition, saying that I could not prove any of the evidence that they found. As a direct result of that, the judge held the matters for a hearing. And as the judge held the matters for a hearing, I brought to light that the victim said that she did not know if her rapist ejaculated in her vagina. Therefore, that set up the fact that the Circuit Attorney's Office saying that the victim told them that the rapist did not ejaculate. However, based off of the sworn testimony and the victim's deposition specifically stated that she did not know if her rapist ejaculated. And so as we went on through the DNA testing process, the medical reports that came to light after the DNA was over with was in the St. Louis Circuit Attorney's Office possession. They never disclosed these documents to us in the clear form where we can discover any of the evidence. And so as a direct result, after we did the DNA testing process, the DNA came back not to match me. Once the DNA came back not matching me, the St. Louis Circuit Attorney's Office, knowing that they had this medical report in their possession, and they never disclosed it to my lawyer, neither to the DNA judge, knowing that they had these documents in their possession, they began to argue that the DNA evidence that they collected from the victim belonged to the victim's boyfriend. The victim boyfriend was in the courtroom right next door to where I was in the courtroom, asking for my petition to be granted for DNA testing. And we just happened to speak with them, consent to giving us a DNA sample, his DNA, and we sent it on to the lab. The DNA came back not to match my boyfriend. As a direct result, the judge ordered the St. Louis Circuit Attorney's Office, a guy by the name of Edmund Joseph Costaco, to bring the victim back into the courtroom and have the victim give specifications as to who the DNA could possibly belong. The victim was brought back into the courtroom, and as a direct result of the victim being come back in the courtroom to testify, when she was told that her boyfriend did not match the DNA, she claimed that she had sex with a guy that was deceased. This guy's name was Fred Knox. We contacted the FBI, and the FBI had released a vial of Fred Knox's blood because Fred Knox was killed in a vicious murder in St. Louis, on St. Louis streets at that time. And as a direct result, we ran the DNA through the Religion Technologies down in Louisiana. It's a DNA lab down there. And after we ran the DNA through the computer, the DNA came back not to match Fred Knox. The woman who claimed that she had sex with Fred Knox was turned out to be not truthful about Fred Knox being the person who his DNA belonged to. When that happened, the judge ordered that the victim's testimony be held until further testing is conducted. So when they did that, they issued an order for another hearing to make a determination about who the DNA actually belonged to. Once the judge issued an order for more DNA testing, the victim came back into the courtroom and testified that she had sex with two other guys that she don't know and she don't remember. She don't remember their names. All the time while we're going through this testing process, the St. Louis Circuit Attorney's Office had State Exhibit 20B, which is the victim's current medical report. And in the medical report, it says the victim had not had sex for 2 weeks prior to the rape happening. As a direct result of that, the judge issued an order to the St. Louis Circuit Attorney's Office that they provide findings of facts and conclusions of law, and we file findings, facts, and conclusions of the law and submit them to her. As a direct result of that, the judge came back and found that based off what the victim said in the DNA testing process, that she had sex with other individuals. Even though the judge did not know the medical report, which is State Exhibit 20B, the clear medical file of the victim never existed. The judge did not search the record to find out if evidence ever existed. And as a direct result of that, it could not have ever been shown that I was the actual rapist of the woman if she hadn't had sex for 2 weeks prior to the rape. As a direct result, the judge denied my rights. This is what my lawyer that I have on my case now. His name is interesting. Out of St. Louis area, and Paul Castellero out of New York. There was Paul Castellero is the director, the legal director for Centurion Ministries. They are instrumental in bringing innocent individuals all over the United States. But they stepped in on the case. They discovered, they went down to the St. Louis Circuit Attorney's Office and discovered the medical report that the St. Louis Circuit Attorney had done possession. And as a direct result of that, that's when they asked for copies of medical reports, which they did not want them to have at first. But somehow they gave over medical reports. And as a direct result of that, we were able to file a petition in the St. Francis County Circuit Court using newly discovered evidence involving Brady violation. Brady versus Maryland is a case where different individual is being held unlawfully incarcerated in whatever institution. He makes evidence to show his actual innocence. As a direct result of showing and in the court, the prosecutor, which is the St. Louis Circuit Attorney's Office, and the Missouri Attorney General, they teamed up and confronted the circuit court in St. Francis County, where opposition for writ of habeas corpus was filed. And they told the court not to allow evidence to the fact that my attorney could have gotten this evidence based off of after the judge to get this evidence up. But for some unfortunate reason, we were unable to get the judge listen to reason, and the judge denied my petition. As a direct result of that, we now petition the St. Louis Circuit Attorney's Office up under the section 517.500, which is if St. Louis Circuit Attorney prosecutor case, an opportunity to go back and look into the case and discover whatever information we have. Now, we use evidence from Brady versus Maryland to justify our position. It shows the circuit attorney's office, the circuit attorney down in the state that I'm being held unlawfully and he's being violent of my constitutional rights. Due to the fact that St. Louis Circuit Attorney's Office withheld material and essential evidence from my defense attorney, and they stopped the DNA judge from releasing me based off of their withholding this evidence as well. And that's all of that. This is how we are now being shown in the St. Louis Circuit Attorney's Office the case is there. Now the Circuit Attorney's Office, somebody with condition to take it. And we're trying to all of the evidence that we have show the St. Louis Circuit Attorney's Office there's a manifest and fundamental discrepancy in justice that has taken place due to the fact that the prosecutor allowed our witness to go into the court and testify falsely that she had sex with several people prior to the rape, which according to Fredrick Lowebey, they have to disclose any favorable evidence to the accused so that the accused could have an opportunity to defend against any evidence that they have. And as a direct result of that, I've been fighting tooth and nail to have this case overturned by using the Brady versus Maryland standards that they have. And as a direct result of that, I know I'm using the direct result, but everything is the result of me being able to articulate these facts in a fashion that the St. Louis Circuit Attorney's Office now, up under the leadership of Gabe Gore, to review all of the evidence so that he can see that, I am being held unlawfully in now, as the St. Louis Circuit Attorney's Office doing the DNA process, were able to withhold evidence of the medical report. They were in violation of a case called Mayview versus Illinois. At this time, the prosecutor should have stopped and told the court, as well as my defense attorney, that they were allowing the victim to testify falsely to the fact that the evidence shown from the victim who was allegedly raped on May 21st, 1988, that she couldn't have possibly had sex with all of these guys because as a direct result of that situation, the medical report said once she was examined directly after the rape happened, she told her examining doctor that she hadn't had sex 2 weeks prior to the rape happened. That sperm that was found, and the court refused to let me out on belong to the actual rapist. The rapist has been left in society for the 30 almost 38 years that I've been incarcerated.
My goodness.
So I was left. I lost my mother. I lost my father. I lost two of my brothers. I lost all my aunts, my uncles, and my grandparents. And I lost one of my sons as a direct result of me being incarcerated in the state of Missouri.
Wow. So if I could back up just to get clear on a couple of things. First of all, I think the people would be really interested in how you found a lawyer or a team of support people to help you with all of this. How have you made this happen? Well, I mean, how much outside help have you had in making this happen for yourself? Yeah, did you hear what I said? Oh, okay, okay. I said, given all that you've been through and everything that has happened, I think people would be interested in knowing how much support you had from the outside. How did you find lawyers that would actually follow through with this for you? And did you have a team out here of people who have been working with you for these 30 some years to bring all this forth? How did you make that happen?
Well, well, United States of America and Canada. And they were headed by James C. McCloskey, who was the executive director of Centurion Ministries at that time. And I called him one day on the phone and I told him, I said, man, I need a lawyer. He was like, what are you talking about? I said, man, I need a lawyer. I got my case in court and I got the judge to grant me DNA test. And he was surprised at it because every time I called him, he kept telling me that they didn't have the resources at that hour. And so the one time I called him, I told him, I said, well, I got a hearing coming up in court, and I would like for you to be there. And he flew down from Preston, New Jersey, because that's where Centurion is based in New Jersey. And he flew down and he sat through the hearing. And from that point on, after he reviewed the documents that I had in my possession, I sent them to him. He agreed to take my case.
So in some ways it's your persistence, and in other ways it's a miracle. I don't know. I mean, I don't know how else to say it, is that it's just a miracle. Because as you know, most people have can hardly get anybody to listen, let alone to fly somewhere to actually go to a hearing and then take the case. So you're very, very persistent, and you're also very, very fortunate. Yes. And if I understand correctly, correct me if I'm wrong, if I understand correctly, you are now in the process of either getting another trial or being exonerated. Am I right about that?
Yes, yes. Process in October of last year, the St. Louis news base, First Alert 4, came to visit me, and I gave an interview with St. Louis First Alert newscasters, and as a direct result, we caught the circuit attorney's office off guard and bringing this evidence to him because he kept ignoring it. And so when it came out on the air that uh, the St. Louis Circuit Attorney's Office had withheld this medical evidence from us, this is what sparked a whole lot of stuff through my attorneys. I have an attorney down in St. Louis. His name is Richard H. Spencer. He's been instrumental in my case since 2010. They brought him on because he's one of the best guys in the situation to help people like me out of these unlawful convictions. You know? And as a direct result, they allowed them to explore all of the facts of the case and interview me. And so when they as a direct result of Centurion Ministries coming to my rescue, I've had tremendous support, man, coming in from everywhere.
And that's wonderful. I mean, it really is wonderful. And you've been working at this for 30 years. Is that correct? 38 years total. 38 years. So, and I'm assuming you started working on it right away when you got incarcerated, right away when you went to prison is when you started working on this.
No, I was working on it. When I got sent to prison, I was working on it. And then, like I said, all the time, everybody says that everybody claims to be innocent, but if you have DNA from an individual that says that he's not guilty of a crime, and the victim is examined by a doctor right after the rape was supposed to have happened, then the circuit attorney's office, the prosecutor, withholds his evidence from him. That's an indication that there's an injustice that has taken place.
For sure, there big injustice. Yes, a lot of it. Well, and we know that there are people there are people who are guilty, but there are also people who are not guilty, and it's very very difficult to prove that you're not guilty once you've been convicted. It's really hard for the courts to back up and say, "Gee, we made a mistake." I mean, that just doesn't hardly ever happen. So you've really 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 been blessed.
So I just want to say this: that my judge, my DNA judge that I had, she didn't want to hear anything. She made the determination that I was guilty based off of what the victim said all the time. My DNA judge didn't even know that State's Exhibit 20B existed. That the victim said that she had not had sex for 2 weeks prior to the rape, to the doctor who examined her right after the rape happened. So if the doctor examined her less than 30 minutes after the rape was supposed to have happened, and the judge did not have this information, then the judge should be held at some type of fault as well, because she didn't give me the benefit of the doubt. And I understand people say that judges are human. I understand they are human, but she didn't even give me the benefit of the doubt, because when the DNA came back not to match me, the first thing they said was that it came from a sexual affair that she had with other individuals, and as a direct result of that, this shows that the sperm did belong to the rapist. But all the time, the judge didn't even have all of the facts, and they left me in prison 18 years after I got found not guilty of this DNA not being mine. But what's worse too is that when it was brought to the judge's attention, I wrote the judge personally on my own after she retired, and I asked her, could I get her help in helping me get free? I wrote her letter, and she wrote me back, and she told me she sent my case down to the judge that took her place on the bench because she retired. And when the news reporter went to go speak with her, she told him she didn't have nothing to do with the situation about the evidence missing about State Exhibit 20B. But she went on the record saying that she scoured the whole record and she found that there was no evidence showing that I was innocent. But here it is, we have State Exhibit 20B that says that the victim had not had sex for 2 weeks prior to the rape, that they withheld. This is the Brady violation that everybody missed. And right now, to this day, the prosecutor is saying that the actual instance is a high burden. You can't get any higher than what I have right now. Because if she was raped and was taken to the hospital and told that doctor while he was examining her that she hadn't had sex in 2 weeks, why was it that important for the prosecutor to withhold his evidence from us? Why was it that important for the prosecutor not to give us this evidence? Because I would have walked out of this courtroom scot-free. And I'm going to tell you something else. The victim's identification of me, she said she remembered me because I had freckles all over my face. So I don't have now one freckle on my
Oh
face.
so she didn't even have the correct not person. She didn't even have the correct not person. Oh my. Well, you have certainly been through it. You have certainly been
And
through it. And
and I'm gonna tell you, it's so bad for the victim, because she died.
how long
My
ago did
baby
she die?
died.
How long ago did she die? She died 6 or 7 years ago. Okay.
She died of drug overdose.
Ah,
And I feel so sorry for her because I don't even hold anything against her no more, too. I don't hold anything against her because for once, too, she did not deserve what they did to her. And I'm thinking that by them putting that pressure on her to have force her to say this and say that, this is how this turned out. That lady they might have drove that lady to use those drugs like she used those drugs. You know?
it certainly could have
And
had that. Certainly could have. It was very traumatic for everybody. I mean, it's traumatic for her. It was very traumatic for everybody. And uh, yes, and people find ways to escape the trauma, the feelings of trauma. And you may be, I mean, you certainly could be correct that she had guilt and could never get out from underneath it. That's entirely possible. That's entirely possible. Well, I'm sure glad for you that you were persistent and that you found people to defend you and to follow through and to make this happen for you. And I think that your story will be inspiring to other people and loved ones who have people who are innocent. I mean, it's very, very hard to fight. It's very, very discouraging, and it's very, very difficult to stay fighting for someone. I mean, it's years, like you say, it's 38 years. It's years and years and years. And so staying involved and having a team of people and then other people joining along the way to help with the fight is very inspirational. And that's I mean, I of course I want the very, very best for you. The larger picture of what I want is for people to hear that you can win if you are willing to fight for the right. It just takes a long, long time and a lot of dedication. And that's really important for people to know. So I really, really want to thank you for doing this interview, and I will get it put up on the YouTube channel within the next couple of days, probably. Well, yeah, within the next couple of days, and Will know, so he can let you know the next time you talk to him that it's up and running. Okay. Well, and I
to include me.
Well, and I thank you very much for being willing to do this interview. And I also am grateful for the state that your state allows this lengthy phone call. In Iowa, a person can only get 20 minutes. That's the limit. So I mean, there's a lot of things that prison has pros and cons, and they're mostly cons, but at least in your state you get longer phone calls. So I'm glad you got to be able to tell your story. I'm really glad for that. And I wish you the very best. Yeah, I wish you the best.
All right, thank you.
You too, and take good care of yourself. And let us know when you get out. Okay. 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 Take care. Okay. Thank you. Bye now. Well, that was quite a story and quite an interview. And like he displayed to you, it takes a long time to fight and win a case when you have been convicted. And I'm glad that you got to hear someone who actually has been able to do that and is actually going to get relief. That's rare, and I'm really fortunate to be able to talk to him and to interview him and to that he was willing to come on this channel and let you people know, let all of us people know that that's possible. So with that, I will close for today. And once again, this is Iowa Prison Perspectives, and I'm Sue Hutchins. And please let me know your comments, whether you agree or disagree, what your thoughts are, and just email me or Gmail me at iowaprisonperspectives.com. And that's, or .gov, or no, .com, at gmail.com. I'm sorry. Um, it's iaprisonperspectives@gmail.com. And I thank you very much for your time, and we'll see you again soon. Thank you very much. Good night.